All right, so this is terrifying. So it looks like the worst is going to happen. It is looking, at least according to all the court watchers, like the Supreme Court is going to side with the government on interfering with tech platforms, although, of course, they wouldn't put it that way.
So this is formerly Missouri versus Biden. It has another name now. I forget what it is. But this was the big censorship case where the federal courts, the lower federal courts, ruled that the Biden team could not contact social media companies with, let's say, requests on what to censor and what not to censor. And then the Biden team vowed to fight it at the Supreme Court, and that's what this is.
Yes, and this is also, the case was heavily based on the Twitter files, which if you read Matt Taibbi's site Racket, he did an article about how the New York Times actually wrote this completely distorted hit piece on Taibbi, Schellenberger, among anybody else who's been in this space advocating for free speech and arguing against government interference. They framed the entire article as the forces of misinformation are winning. Right. And if you are familiar with the facts, it was just sickening. It was a sickening article. But this from WAPO is a sickening outlet, but they played it pretty straight here. The Supreme Court seemed prepared Monday to reject a Republican-led effort to sharply limit the federal government from pressuring social media companies to remove harmful posts and misinformation from their platforms. A majority of justices from across the ideological spectrum expressed concern about hamstringing White House officials and other federal employees from communicating with tech giants about posts the government deems problematic that are related to public health, national security, and elections, among other topics. The case involves a lawsuit initiated by two Republican-led states, Missouri and Louisiana, and individual social media users. They accuse the Biden administration of violating the First Amendment by operating a sprawling federal censorship enterprise to influence platforms to modify or take down posts. Now, again, you can find a lot of this stuff in both Taibbi's work. Schellenberger has also done articles about this. The last drops they did on this a few months back, that was right around the time we had Matt on the show. When was that?
That was this last time would have been, I think it was like December or something like that.
Right. So if you go back into some of what he dropped, it really connected all the dots. What they're saying here is speculation. No. They proved very clearly that the government was using not-for-profit companies as proxies for the government to investigate. And what's also not being mentioned in this article in particular is the fact that most of these users who were swept up in this were not spreading misinformation. They were just individual users doing their thing. You're talking about grabbing people with 12 freaking followers and accusing them of being Russian agents and all kinds of things. And it's also not accounting for the level of coercion that was involved. The Twitter files show FBI agents. What was his name? Elvis Chang, best name ever for an FBI agent. Just, you could see how they're working an op on these people, gradually manipulating them into working in partnership with the government, which, as we'll see, is a point Alito made later. Justices Alina Kagan and Brett Kavanaugh, who previously worked as lawyers in Democratic and Republican administrations respectively, suggested that government exchanges with the platforms and media outlets were routine occurrences and did not amount to censorship or coercion in violation of the constitutional right to free speech. Chief Justice John Roberts seemed to agree, noting that the federal government has numerous agencies that do not always speak with a single voice. Quote, "It's not monolithic," he said in an exchange with the attorney representing Louisiana. "That has to dilute the concept of coercion significantly, doesn't it?" One wonders if what's in the Twitter files was part of the case, because it almost seems like they didn't read them. I mean, I'm sure they did. That had to have been part of the supporting evidence. But In principle, yes. And we'll talk about it more at the end. I understand what they're saying in terms of where would the line be on what the government is allowed to say regarding public health or public interest or so on and so forth. But if you look at the Twitter files, it goes well beyond that. There's when you look at the arguments that are against the case against the attorney generals, it seems almost willfully naive. It is very much, well, just because Mr. Luigi came to your store and suggested it would be a shame if something happened to it, that does not constitute a threat.
Well, this is the thing about this ruling, and we'll get to it because we have to get through all the exhibits, obviously, and then we'll talk more. But I do understand where they're coming from. I just don't agree.
I do.
With it.
I do as well.
Like, it's not from outer space. Like, yes, in theory, the government can advise a social media company, hey, be on the lookout for this. Like, in a theoretical situation, the government could say, look, we have information that the public doesn't have completely, and be on the lookout for this because this is going to fuck this up if it gets out, and we can't have people running their mouths about this. So just be aware. But that doesn't necessarily, that is not by definition coercive in theory. But in reality, of course it is, especially in a moment where the government has very little legitimacy with the public and where the government is known to lie in a crisis, as has been proven time after time. So I understand like the theoretical point you're making. It just doesn't jibe with the reality of the moment. Like, yes, if we had a government that we had faith in, sure, but in a democracy, you don't always get a government you have faith in because democracy is messy.
That's it. The idea of if we have a government we have faith in, that's not a standard.
Right, that's not a standard. Exactly.
The entire legal system is based on worst case scenario. Exactly. That's what those checks are. Otherwise, you could just have a monarch.
Yeah, that's a
monarch. Monarch much more efficient. We don't have that because you got to assume the worst about the government. This country was conceived on the assumption of worst case scenario. The government is terrible. How do you hamstring the government? How do you have the least government possible and still have a functioning society?
Right.
And when you look at the realities, that's why I'm saying I don't see how you could. I too see where they're coming from, but if you read the Twitter files, it's clearly beyond that. It's clearly beyond just. Would I necessarily have a problem if the government just said, hey, we're worried about Russian disinformation? Okay, I might find it sleazy. But if you just left it at that, okay. This is almost a fantasy world where there's no implicit threat in what the government was doing.
Right.
This is the same government that brought all these CEOs before Congress and made them testify.
Right.
That threat is there. This is the same government that has within its power revoking the article of law that shields them from lawsuits for what they publish, and they could revoke that. There are things the government could do to them, and to suggest, well, no, I mean, they're just talking is incredibly naive.
Yeah.
The High Court on Monday appeared ready to embrace a narrow ruling, with several justices suggesting that the states and individuals behind the lawsuit did not have sufficient legal grounds to sue the Biden administration. Now, that would be interesting if they just punt the whole thing that way.
Right.
On a lack of standing. Some said the individuals could not show a direct link between the government's pressure on the platforms and the tech companies' removal of posts that the government deemed problematic. Kagan pressed Louisiana's lawyer for evidence that the government, not the social media companies, was responsible for taking down the posts at issue. Quote, how do you decide that it's government action as opposed to platform action? Well, I don't know. All the evidence of the government going on fishing expeditions and giving them lists of users that they find problematic.
Volume 1 of the Twitter files was all about the Hunter Biden laptop, how Twitter took that down at essentially the request of government agencies. I mean, that was what happens. Right. So when you say, well, how do you decide if it's a government action or a platform action? That's the very point. It's hard to tell who was really in charge of that, because technically, yes, the platform did it, But we know based on those exchanges that the platform, who's the guy's name? Who's the guy who was calling the shots? Some weird name. I forget.
Who's calling the shots where?
At Twitter. I forget the guy's name.
Oh, I know who you're talking about. I forget him.
I forget his name too. But we know that he had doubts about whether or not that actually constituted a hacked materials violation. And so in that case, I mean, yeah, it's technically a platform action, but we know now, it's documented, that the platform itself didn't want to take it down. The government said, we want you to take this down, which there is an implicit threat of force there. There is an implicit coercion there because they have the power of the state. Yoel Roth, thank you for that over on Rumble. Yoel Roth, appreciate that.
We have the best people.
We have the best people. Yes, thank you. Anyway.
Yes. And again, I mean, this is really the argument the justices are making is the argument that when the mob boss comes into your store and says, I'd like you to do something, there's no implicit threat. There's no
implicit threat, right.
Well, of course there is. They're the fucking government, and these tech companies live or die by also government contracts.
Right.
Now, you don't get the government contracts if you don't do what you're told.
Right.
The First Amendment prevents the government from censoring speech and punishing people for expressing different views. But the Biden administration says officials are entitled to share information, participate in public debate, and urge action as long as their requests are not accompanied by threats. So, I mean, this is kind of what it all hinges on, what constitutes a threat.
Right.
Realistically, when the government contacts you, it's a threat. There's a threat inherent in that. And that has to be addressed realistically before you can get to any kind of a judgment on this.
Yeah, the IRS doesn't send you a letter. Your taxes are late. Just letting you know. Don't worry about it or anything.
Exactly.
No sweat.
Exactly. Principal Deputy Solicitor General Brian Fletcher, representing the Biden administration, said government officials have long-standing authority to use the bully pulpit to inform and persuade. The lower court ruling, he said, would prevent thousands of government officials, including FBI agents and presidential aides, from addressing threats to national security and public health. The attorneys general of Missouri and Louisiana argued that the federal government went too far by coercing social media companies to suppress speech of individual users and by becoming deeply involved in the company's decisions to remove certain content. Tech companies, they said, cannot act on behalf of the government to remove speech the government doesn't like. Louisiana Solicitor General J. Benjamin Aguinaga said the Biden administration had subjected the platforms to unrelenting pressure using profanity and badgering, not the bully pulpit. That's just being a bully, he told the court. Now, one example they cite here, I didn't pull it, but some of you might remember when Biden accused the tech platforms of killing people. And then later on, he had to clean it up and say, no, I meant the users. I didn't. He said the platforms at the time. All right. So we have Ketanji Brown Jackson, who, frankly, the idea that a Supreme Court justice would make the argument she makes here is really terrifying. So let's hear that.
Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that, because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
I'd be very happy to give you some much needed help with that. The First Amendment exists to hamstring the government. That's the
Yes.
whole point of the First Amendment.
Yes.
The whole point of
Yes.
the First Amendment
That's
is
why
to
this is
hamstring
an
the government.
incredible formulation.
Right, exactly. Like there. I mean, does that answer your question?
The
College
government-
dropout here, not a lawyer, but I'm pretty sure I know that. That's about as basic as it gets, is it not?
Let me ask Miss Jackson. Maybe she'll email us. Maybe I'm sure she's watching. Okay, so we have First Church of Christian Scientists in this country. You don't believe in medicine, practice of medicine. Does the government go and contact them and tell them you're not allowed to believe that? You're not allowed to teach people that?
Social media, right?
Yeah, you're not allowed to tell people that. There are all kinds of things people believe that are not sanctioned by the government. And the government, in a situation like that, is free to speak, present your argument. This is this is almost historically illiterate. Throughout the history of the country, there have been people who believe things that are contrary to the party line, to the government's line about what to believe, and we settle it in the field of debate, although we haven't always. Right, the Sedition Act that is getting some new life that was brought about in World War I. Yeah, I mean, we have tried at times to give the government powers, or the government has attempted to take powers, and sometimes successfully. That would stop that. We tend to see those things as aberrations and violations of the First Amendment and the right to free speech that we assume as Americans. The fact that you got a Supreme Court justice who is bothered by the idea that the First Amendment hampers the government. What the fuck are you talking about?
Well, this is just it, right? I mean, so we talked about earlier in the segment how we understand the theoretical basis for this looming ruling. It's not technically a ruling yet, but it looks like it will be when you have Kavanaugh and Jackson agreeing on something that pretty much means it's a done deal. You know, the ruling makes sense only in a theoretical and highly idealistic context. It doesn't make sense in a realistic context.
Exactly.
But now she's saying, now she's going to the real world when it suits her case. She's saying, well, yes, the government has the right to speak and people theoretically have the right to listen, but in reality, people don't always listen. So when people don't listen to the government, they have to be able to take it a step further and force them to listen to them. But no, that's not the way it works. So, see, they kind of shift from the sort of real world to their ideal vision of the world, depending on which narrative or which micro narrative within the overall narrative of the case suits them to make any particular argument that they want to make. And at the end of the day, what you have is a ruling that is going to read something like, well, just because the government tells you to do something doesn't mean they're forcing you to do something. And they have to be able to force you to do something, though, even though they're not officially forcing you to do something, because we can't trust the people to listen to them unless they're forcing you to do something. That's basically the subtext of what this is going to read like.
Exactly, because this assumes, and you can hear this in this entire formulation from Jackson, she assumes the government is the good and the right.
Right.
So really what we're talking about is how much power should they have to stop the wrong and to assert the right. The idea that the government may be wrong and doing a lot of harm by shutting down the debate, as friend of show Jimmy Dore just tweeted out that the New York Times put out an article now, 4 years on, the lockdowns were very damaging to people. They actually caused a lot of trouble, particularly for children who were kept out of school. What was the government saying at that time?
But that doesn't even, I mean, yes, I understand what
you
you're
were
saying.
some kind of crazy cuckoo pants if you asserted that at that time.
But even if they were right, like,
even
yes, I
if
agree,
they were,
but that doesn't even matter.
Of course,
even if the
regards
government is right and the people are wrong, the Constitution allows for the people to be wrong, and that gets settled through the democratic process. That's why we have elections. That's why we put in place leaders who are going to get things right and not wrong, right? Just because the people are wrong doesn't mean they don't get to speak.
Right. Absolutely. That is the principle. But even on the level that she's talking about, it assumes that the government asserting that power cannot be harmful. And it can. And we've seen it in the very recent past, that allowing the government that kind of a megaphone with that and shutting down competing voices, as most of these media companies did. Remember, X was still in the hands of Dorsey at that time. You couldn't even talk about the lab leak. Right? We had a podcast at that time. We didn't talk about that shit because you couldn't. Couldn't. We just stayed off the topic. In the middle of COVID, we hardly talked about COVID.
Right.
And I just want to point out the conservatives on the court, 3 of them anyway, were the only ones who made the arguments we're making. So tell me again how I have to vote Democrat so that we can get more justices like Ketanji Brown Jackson on the court. Tell me how to protect my freedom. I need Democrats to pick the justices. The toughest questions for the Biden administration came from conservative justices Samuel Alito and Clarence Thomas, who, along with Justice Neil Gorsuch, dissented earlier this term when the majority temporarily blocked the lower court ruling, allowing contacts with social media companies to continue. Alito said the intense back and forth and constant demands from the Biden administration at the height of the vaccination campaign in 2021 suggested the government was impermissibly coordinating with and coercing social media companies. The administration was, quote, treating Facebook and these other platforms like their subordinates, he said, noting that he could not imagine government officials making similar demands of news outlets. I mean, that's a little naive on his part, but his point is well taken. Quote, do you think that the print media regards themselves as being on the same team as the federal government, partners with the federal government? Alito asked the government's lawyer, pointing to the dozens of journalists sitting inside the courtroom. Now, just to address this, I think anyone in this space knows that the government does lean on media companies. We've seen the evidence of it. But if you go through the Twitter files and you look at the way that they're insinuating themselves with these platforms, yes, there's definitely a difference from the way they would deal with the press and with journalists. It's very much like, hey, don't you want to be on the government's team? Can you help us out with this? I don't think they do that with the journalists. It's a little different. Not to say they don't coordinate, but it's not that in that way. The initial ruling in the lawsuit came from a conservative district court judge in Louisiana who said that the Biden administration appeared to have operated, quote, the most massive attack against free speech in United States history. The court's order barred thousands of federal employees from improperly influencing tech companies to remove certain content. The U.S. Court of Appeals for the Fifth Circuit narrowed the decision to a smaller set of government officials and agencies, including the Surgeon General's office, the White House, the Centers for Disease Control and Prevention, and the FBI. A 3-judge panel of the appeals court said the White House probably, quote, coerced the platforms to make their moderation decisions by way of intimidating messages and threats of adverse consequences, unquote. The panel also found that the White House, quote, significantly encouraged the platform's decisions by commandeering their decision-making processes, both in violation of the First Amendment. Close quote. In October, the Supreme Court intervened and allowed the Biden administration to resume communications with social media companies while the litigation continued. Thomas, Alito, and Gorsuch dissented, saying that government censorship of private speech is antithetical to our democratic form of government. Now, this is another one of these examples of how we live in topsy-turvy land. I've said this many times. I've been saying this for since we started getting into this election cycle. If you held a gun to my head, as somebody who really feels that all rights proceed from the right to speech, I'd have to vote Republican at this point. Like yes, you do have the conservatives on the court like Roberts who seem sympathetic to the government's argument, but insofar as you're getting dissent, it's uniformly from the conservative justices.
Well, yeah, and speaking of voting, look, this is one of those rulings that I can say I disagree with it, but I understand it. Like, am I shocked that they're ruling this way? No. That bit of sound that we played from Jackson is shocking. the overall ruling is not shocking. It just does not show any real prudence, really. That's the point, is that it doesn't account for the reality of the moment we live in, or of the very sort of like nature of a democracy. The nature of democracy is that it goes wrong a lot. And as Russell said, you have to account for worst case scenarios when you think about these rulings and the kind of precedents that they set. But I do understand the ruling. And so you have to accept the ruling, because I do understand where they're coming from, even though I, of course, would not have ruled this way. So in this case, this is the way that a country is supposed to work, like ours, right? In this case, when the Supreme Court makes a ruling like this is when it falls to the other two branches to remedy this, or at least nullify it. So now is when, in a functioning democracy, the people would say, okay, well, if the High Court rules that government speech is not coercive by nature, we now have to elect representatives who are not going to be coercive when they speak, right? That's where we have to actually mobilize now. Of course, we're not going to. We can't, right? And so this is why the country is going to hell, because in a functioning system, we would say, okay, if the court says that government speech is not coercive by nature, but this group of people are running it as though it is, we have to replace the censorious government officials with the non-censorious government officials. So under President Thomas Massie, this ruling wouldn't really matter all that much, because Thomas Massie is not going to use his power to shut down freedom of information, freedom of ideas.
All
we
right,
know Joe
don't
Biden
do the
will.
endorsement yet. They haven't brought us the cash.
I'm not saying like on balance he's the best, although he probably is one of the best.
We're waiting for the paper bag of cash.
Yeah, right, exactly. But I'm saying in theory you can elect someone like him, in which case, under a reality governed by a guy like Thomas Massie, this really wouldn't matter all that much, because he wouldn't coerce social media platforms to do it. He wouldn't order them around. Biden will. Trump probably would under the right circumstances too, right? And so you got really no good options.
Okay, so regarding what you're saying, I'm going to recommend this article actually in a Chomskyan spirit. This is the article that Matt Taibbi went off on that really misrepresents him and Schellenberg. But it does call to mind Chomsky's observation that you should read the Times because there's a lot of information in it, kind of leaving it on you to read between the lines. And one of the things I did get from this article on that level is the war that mostly Republicans, mostly conservatives have made on these platforms has had an effect. Because while this article is lamenting the way they've backed down from a lot of these policies and stopped enforcing them, of course, that's cause for celebration. So it's worth reading, just, dismissing their tisk-tisking tone and seeing, well, insofar as these efforts are being shut down, it is, as Keaton is saying, through electing representatives who are extremely hostile to this regime and are using the powers of their office, like Jim Jordan, to make life hell for these people. The article gets into very much lamenting it, how thousands of subpoenas have been sent to these companies by Jim Jordan's committee, which has made them very hesitant to continue to get into this territory. Good.
Oh, well, exactly. And look, the underlying question of most, if not all, Supreme Court cases, and I'm not a legal scholar, so you could probably come up with an exception or two, but essentially the underlying question when a case gets before the High Court is this the realm in which the court can rule, or does the court kick it back to the legislative branch or the executive branch? And by kicking it back to the executive or the legislative branch, what they are in theory doing is kicking it back to us. As in theory, the people, as the voters, right? They're saying this is not for the court to rule. This is for the people to hash out, and they will elect people who will interpret this question that we are now dealing with in different ways. And it's going to go back and forth, right? In most cases, there is going to be a back and forth here. And that's where it falls to people to sort that out. And the way it's supposed to work is we vote for people who are going to manage this power that the court has now handed the executive branch in a responsible way. And if we don't do that, that's our failure. Now, of course, when you have a country as corrupt as this one, it's kind of unfair to blame the people since the people have very little actual real world input. But in theory, right, the way the plan was drawn up, it's now on us.
Please clap.